Mr. President, when I went home to Illinois, I can't tell you how many people who know that I chair the Judiciary Committee ask me, what's going on with the United States Supreme Court? Obvious question, because in the last few weeks there have been disclosures about at least one justice on the court that have raised some serious questions. Justices have an important job to fill as one of the major branches of our government. They'll be issuing their remaining decisions for this term, and they'll recess soon until they reconvene in October. But the debate is still going to continue, even if they're not sitting in the court across the street. How will the justices spend their time during these several months when they're not in session? That's really the question. Rest up, possibly, or spend time with their family, possibly, or maybe take a trip or two. There we have a question that is timely. We've learned through recent investigative reporting that some Supreme Court justices on the highest court in the land have enjoyed lavish travel during their summer months. That travel was often paid for by others, and the justices, in some cases, did not disclose this free travel as are required by law. These are the justices on the highest court in the land, and the question is whether they're following the law. They impose legal obligations on citizens across America. Are they living by the same legal obligations that affect them as justices? It's a pretty obvious question. Most notably, ProPublica recently found that in June 2019, after the court issued its final opinion of that term, Justice Clarence Thomas boarded a private jet and flew to Indonesia. Then the justice and his wife spent 9 days island hopping through the South Pacific on a yacht that was 162 foot long. ProPublica estimated the cost of chartering the plane and yacht at more than $500,000. But Justice Thomas didn't pay for that. The travel and trip were provided by a billionaire real estate developer, Harlan Crow, and several corporate entities in Crow's business empire. This is just one example of the largesse provided to Justice Thomas by Mr. Crow and his businesses. It's also been reported that Justice has regularly spent time at a luxury retreat in the Adirondacks owned by one of Mr. Crow's companies, again, free of charge. Mr. Crow has also bought real estate owned by Justice Thomas, including the home in which his mother lives, and Mr. Crow even paid for private school tuition for one of the justice's relatives. Justice Thomas did not disclose any of these gifts, or travel, or lodging, or other benefits. Now let me say at the outset, Justice Thomas is not the only Supreme Court justice, past or present, who's accepted gifts or free travel and failed to disclose them in a timely manner. But the scope and scale of the undisclosed Justice Thomas gifts has gone far beyond anything else we've ever seen. And this highlights the enormous gap in the ethical standards for the Supreme Court justices. We've known this for years. In February of 2012, 11 years ago, I first wrote to Chief Justice Roberts and urged him to adopt a code of ethical conduct to bind the justices, just like the code that binds every other federal judge in America. Chief Justice Roberts failed to act when I wrote him 11 years ago. Since then, the court's ethics problems have just gotten worse. Last month, after ProPublica published its first report on Justice Thomas' undisclosed travel, I renewed my call for Chief Justice Roberts to clean up the ethical mess across the street. And I personally invited him to testify at a hearing before our Senate Judiciary Committee, so he could speak directly to the American people. You say, wait a minute, how many times does a Supreme Court justice come across the street and formally appear before Congress? Well, it turns out 92 different times since the year 1960. 92 different times. So they come across the street when they have something to tell us. I think they should be coming across the street to discuss the ethics of the court. This would have been an opportunity for the Chief Justice to reassure the American people and start to restore trust in the high court. I watch some of those news programs on Sunday morning. I'm a typical politician, and they have the polling data of what people think of the Supreme Court. The numbers are bad. They're almost as bad as Congress. And the fact is, they can do something about it, and they should. This court's trust in this court has fallen to the lowest level in 50 years. And unfortunately, the Supreme Court's Chief Justice didn't accept my invitation to walk across the street. Time and again, I've made clear one point I want to make clear today. The Chief Justice, John Roberts, has the ability right now, the authority right now, to impose higher ethical standards on his fellow justices, standards that would be transparent and enforceable. Wouldn't that be refreshing? He could take that action today, but for some reason, so far, he has declined the opportunity. And if he won't act, Congress must. We cannot tolerate a system in which the highest court in America has the lowest ethical standards in the federal government. And we certainly should not begin another Supreme Court summer recess where justices can take free trips and travel under an inadequate set of ethics rules. Last week, Chief Justice Roberts gave a speech, and he said something encouraging. I quote, he said, "I want to assure people that I'm committed to making certain that we as a court adhere to the highest standards of conduct." He said, "We are continuing to look at things we can do to give practical effect to that commitment." While I appreciate the Chief Justice's commitment, the fact is we need action, and he doesn't need to look far away for solutions. We have known for years what the court needs: binding rules and enforcement mechanisms, just like every other federal judge has operated under for a decade. If every other federal judge has ethical standards and disclosures, why does the Chief Justice for the highest court in the land not have at least those levels of ethical standards, but even higher? The Senate Judiciary Committee has the responsibility to exercise oversight over the federal judiciary. We take it seriously. We have held 2 ethics reform hearings so far this year, and soon we'll consider legislation to restore trust in the high court. When billionaires and other people with interest before the court try to make friends with the justices through gifts and luxury giveaways, and when they obtain special private access to these justices for themselves and their other friends, it's a serious problem. At minimum, it creates an appearance of undue influence that erodes the public's trust in court impartiality. And we don't yet know the full extent of the benefits that Harlan Crow and his company gave to Justice Thomas and his family. Nor do we know yet how many other people and companies with interest before the courts may have gotten special private access to Justice Thomas or some other justice through trips and lodging that people like Harlan Crow have sponsored. My Democratic colleagues on the Senate Judiciary Committee and I sent a letter to Mr. Crow and the 3 companies that we think sponsored the trips for Justice Thomas. We asked him, tell us about the gifts. Tell us about the access of people to Justice Thomas during this hospitality extravaganza. The information would be valuable for us in writing a law for the ethics standards of the court. Mr. Crow responded through his attorney last week with a letter that took some astonishing legal positions. He basically claimed that Congress lacks the authority to either legislate or conduct oversight when it comes to the Supreme Court's ethics. He also tried to assert separation of powers as an excuse not to answer our questions. Of course, Congress has enacted many ethics laws that apply to the justices, including a law we passed just last year, bipartisan law sponsored by a Democratic and Republican senator on stock transaction reporting. The justices have announced they're going to follow those laws. And Mr. Crow is a private citizen, not a branch of government. He can't claim separation of powers as a reason not to provide information pursuant to a congressional oversight request. He's a businessman. He's not a branch of government. If Mr. Crow is convinced he's done nothing wrong, what does he have to hide? Senator Whitehouse, the chair of the Federal Court Subcommittee, and I responded to Mr. Crow last week, informed them that he still has until next Monday, June 5th, to provide the information we requested. As I mentioned, we'll soon be considering legislation in the committee, and his information could be helpful in our legislative effort. Let me close by reiterating that Chief Justice Roberts does not have to wait on Harlan Crow or Congress. He can clean up this mess today by adopting a resolution binding the justices to higher ethical standards. This is the Roberts Court. History is going to write the history of the Supreme Court in the name of this Chief Justice. It happens all the time. He is going to be known as the Chief Justice who ignored an ethical challenge that went to the heart of the integrity of the court, or as a Chief Justice who finally responded in a historic manner to do the right thing for disclosing to the American people exactly what the conduct is of his justices. Chief Justice Roberts has known for more than 10 years that this is a problem and the solution is within his authority. He should act before the end of this Supreme Court term. Don't leave this hanging. Don't leave town, leave Washington, all the justices of the court, unresolved. I honestly believe, whether I voted for them or not, that there are justices in that court who are uneasy and uncomfortable with the current state of affairs. They are trying their level best to follow the law, and they can't explain why others are not. They want to have an opportunity to prove their own reputations and their own integrity, and they should. The Chief Justice should be listening to them, and I hope he is. It's the Chief Justice and the court's time to act. If they don't, we will. Mr. President, I yield the floor.